Hi, everyone. This is Alex Dreyer from the Friday Institute. We are going to be getting started in about 1 minute. So just want to let you know this is the 1 minute warning, and then I'll do a brief introduction and then leave it to our wonderful presenters. All right, so welcome everyone. We have a lot of people. We have over 200 of you right now, currently, 241 and counting. And we're really excited for the North Carolina Equity Conference. This is a really exciting thing. It's our, as you've heard, it's our first time we've ever been doing this here at the Friday Institute. And we've been incredibly overwhelmed by the response and by, again, what looks to be an extraordinary group of presenters. And two of whom are here with us this afternoon. So I am really excited, really excited to welcome Jen Story and Barbara Fetters. They're both from Legal Aid of North Carolina. And they're going to be talking about preventing the pipeline, school-based strategies to keep students with disabilities on a path to success and out of the school to prison pipeline. So just to give you some context of what I'm going to be doing, again, I'm just going to be the host in the background. I'm here to support the presenters. I am going to provide technical assistance to any of the participants who need to, and I'm going to share that session evaluation and certificate information at the end of the session. Don't hesitate to ask questions in the chat. I'll be monitoring that. And I will elevate questions to Jen and Barbara as they come about. So again, without further ado, I want to introduce Jen Story and Barbara Fetters, both of Legal Aid of North Carolina, and let's get going.
Awesome. Thanks so much for having us here. We're really thrilled to be here today and to get to talk to you guys about a subject that we're both very passionate about. So a little bit more about me, because I think it's helpful to know who's talking to you. So as you said, my name's Jen Story, and I'm the managing attorney of Advocates for Children's Services, which is the statewide education justice project of Legal Aid of North Carolina. So we operate as part of Legal Aid, providing free legal assistance to low-income families across the state. And our focus within our project is on dismantling the school to prison pipeline in North Carolina. So we do that through providing representation to students in special education matters, school discipline matters, discrimination, any of the factors that are resulting in kids being pushed out of school. My background is actually, before I was kind of a begrudging lawyer, I kind of worked in more of a social work role before that, started out in public housing, and then spent a number of years working with court-involved kids in the school system. So coordinating wraparound supports for kids who are at risk of suspensions. And that was kind of where my aha connection moment, knew I wanted to work within these systems and trying to keep kids out of the juvenile court system for as long as possible. I'm gonna let Barb, and Barb's actually from the UNC School of Law, so I'll let her share a little bit more about her background.
Thank you so much, Alex and Jen. Yes, and while I would be honored to work at Legal Aid, in fact, I am the director of the Youth Justice Clinic at UNC School of Law. We partner frequently with Legal Aid, and what we do is law students in their final year represent young people in delinquency prosecutions, criminal prosecutions, and then school suspension appeals as well. About 5 years ago, I realized that in order to truly represent young people, we couldn't only work in juvenile court, which is what we had been doing. We needed to also connect up with school systems, because we realized that to keep people from getting entrenched in the juvenile court, getting rearrested, the most important thing we could do was make sure that their needs were being met in school and that they were able to be on a path to academic success. Before I did this, I worked in several other law schools in similar capacities, and my background is as a public defender working for representing young people in delinquency cases.
And so the glaring caveat, as you'll notice from both of our introductions, is we're not educators. And so we want to say from the outset that we know that you all in the school system have to deal a lot with people who are not teachers, who are not in the school telling you how to do your job. And so that is not our intent today whatsoever. We work a lot within the school systems as far as how they overlap with the juvenile court systems. And so we have our experience. And so I want to just kind of share that knowledge and context in hopes that it'll help support you in your efforts to pursue equity and success for your young people in schools. Here we go. So before we jump straight into talking about juvenile courts and students, I want to take a few minutes at the outset. Apologies, I'm going to move some of this around. There we go. I want to take a few minutes at the outset to really ground our discussion in the framework that we're going to be using, in particular to ground it in this particular moment in history and in the theme of this conference. We're also excited to be part of this effort because as we're being called on in this current social movement to rethink and reimagine with our communities the fundamental concepts of safety, justice, healing, our institutions, including our schools and our court systems, are some of the main ones that are being re-examined through racial justice lenses as we're looking at how are these systems perpetuating injustice and inequity, and then also putting on our trauma-informed lens to think through how can we creatively and fundamentally reimagine these systems to instead revision how can they promote healing and accountability. And so those are kind of the grounding principles and lenses that we're going to be using today as we're talking through the kind of the three substantive parts of the presentation. So first, Barb's going to spend some time giving you an overview of the juvenile court system and encouraging you to think critically about the short and long-term harm that students, and particularly students of color and students with disabilities, face as a result of being referred to court. From that grounding, I'll take some time to think through with you all creative options for utilizing special education supports and other school-based supports to help support students to prevent that link between school and court from ever even happening. And then finally, we're going to close by talking through some additional resources that can be accessed in the community. Because again, I want to stress that we fully understand that schools can't be everything to everyone. Now more than ever, you all in the school systems are being asked to do that. And I think everyone's finally taking note of just how much teachers in our schools are asked to take on. The pandemic has shown a glaringly bright light on just how deeply we as communities rely on our schools for everything. And so we hear and unequivocally support the calls for communities to be supporting schools and helping fill in gaps and supporting students. And so we believe that it's through that model that we can also help support these students long beyond the pandemic and keeping kids out of court and in school and keeping families safe and successful. And so as a practical matter, before we jump in, I wanted to talk through, well, like, how do we apply these lenses in our work? What are the questions that we're asking as we're going through our cases? So as you heard from our introductions, pretty much all of mine and Barb's practice revolves around student misbehavior, specifically intervening at those decision points where the schools or the courts are seeking to punish student misbehavior through long-term suspensions or referrals to court. And in that situation, the primary question that the decision makers we're encountering are asking are just, did they do it? Did the student do what we accuse them of doing? Sometimes we have legitimate arguments to say that they didn't, that no, they didn't do what you accused them of, or if it was a different person, you got the wrong guy. In reality, though, a lot of times the students largely did what they were accused of doing by the time they make it to us. However, unless we force the issue, nowhere in these proceedings is there a place for a discussion about why did the student misbehave in that way. Instead, we just jump straight to the how did they act and how can we punish them without ever taking a step back to examine first and foremost, why did the behavior occur in the first place? And so because it's easier to just look on the surface, we see what looks like willful defiance, a student who could but just won't do the right thing. They may be refusing to go to school or skipping class or refusing to do work once they get there. Or maybe they're even getting in fights with other students or arguing with teachers and kind of getting more aggressive and violent at schools. And in a lot of cases, we even hear students saying things that validate those snap judgments. I've worked with a number of young people that, especially when you're first starting, like they'll say, like, I don't care, I don't like this, like whatever. And it just kind of validates that snap judgment of what we see. But I will say that in probably 99% of the cases that I've worked on over the last 15 years, what's actually driving the students' words and actions is far more complex and typically involves some combination related to poverty or unmet mental health needs, unmet academic needs, including unmet disability-related needs. And so one example is that at Legal Aid, we frequently get cases that come to us as long-term suspension cases, often where the student's also being referred to the court system. And so we start, because that's the incident that brought, we look at that incident, what happened that day, did they do it? But then we also always dig deeper to look at, well, what led them to this point? What triggered this event? And it's rarely, as you all probably know all too well, it really just comes out of the blue. It's been building from something. In many, many cases, the student has been failing school for multiple years, and things have just begun to spiral, but it's gone unaddressed, fallen under the radar. Sometimes they have documented disabilities. Sometimes they even already have an IEP, the special education plan, but it hasn't really been changed or updated much from year to year. So they've just been kind of passed along over and over, and this cycle of disengagement and frustration continues until things just erupt. But we only learn this information if we stop and really make that deliberate effort to look deeper at the why behind the student's behavior. And so then once we have that why behind the student's behavior, that helps us make better decisions about, well, how are we as the adults going to respond to it? In particular, thinking through how can we craft a response that focuses on accountability for the student. We're not here to say that students shouldn't have accountability and learn from their mistakes, but also focuses on healing for everyone involved, kind of that restorative model. And I will say that in my experience, this deliberate assessment that I strongly believe all educators want to engage in, it goes out the window when that knee-jerk response of the student acted up, we're gonna suspend and call the school resource officer in. Once that train gets going, there's no room for that kind of thoughtful deliberation of why did this happen and how do we best approach it? And so in particular, it doesn't leave us any room to really think critically through, well, why are we choosing to criminalize this behavior? And I will say, whenever that's been posed before, and I've posed it to people, well, why have you chosen to refer this to court? Honestly, often the answer is like, well, because we can. You know, the behavior meets the definition of disorderly conduct, and the law says that that's a crime, and so we can. But that answer is in no way satisfactory if we are going to be pursuing schools that are equitable and supportive for students. Because first of all, there's the reality that every single day at a given school, when it's operating in its normal capacity, pretty much any student who is engaging in developmentally normative behavior, that behavior could readily fit the definition of disorderly conduct or even simple affray. Those definitions are pretty broad and largely describe adolescent behavior, but we're not sending all of those students home or sending them into the court system. Instead, we know that we're disproportionately sending students of color and students with disabilities into those settings. We also know that referring kids to court simply because we can circumvents any assessment about what we're hoping to accomplish and whether we think we can actually accomplish those goals by involving the juvenile court system. In other words, if our goal in responding to student misbehavior is to create accountability and healing, will the juvenile court system actually help us reach those goals? Or are there other ways that we can invest in the student's school or family or community environments, those environments that we know are going to be the long-term stable settings for the students, so that we can more effectively and sustainably help them reach their goals? And so to be able to help you answer these questions confidently moving forward for yourself, you have to have a grounding in juvenile court and how it operates within North Carolina. And so with that, I'm going to turn it over to Barb so that she can provide you with more information about kind of the what happens next after a student is referred to court as a result of a school-based issue.
Thanks, Jen. So Jen described what happens when a student erupts. And so this hypothetical, which is a composite of several young people that we've represented over the years, kind of constitutes an event like that. So, and we thought that providing you this example would help ground the discussion that follows. So James is a 16-year-old ninth grader who is repeating the ninth grade. He's a talented football player and artist who's close with his mother and younger siblings. He lives in a neighborhood with significant gang activity. He's lost several friends to gun violence. His mother recently lost her job, and the family is now facing eviction. James is failing his core classes. He regularly skips. And so far this year, he's already been suspended 3 times due to arguments and fights with other students. He has an IEP and under the category of serious emotional disability. So what happened with this incident is that James, as he does when he gets stressed out and feels like he can't manage being in school, left math class and started walking towards the exit. And he was singing and shouting. The school resource officer approached him from behind and grabbed his shoulders to try to get him to stop leaving the building. James responded just by throwing his elbow backwards, which hit the school resource officer in the jaw. He then ran away from the teacher and SRO who were following him. And as a result, he received a long-term suspension, and the SRO referred him to court for disorderly conduct. Next slide, please. So I want to break this down exactly the ways in which school issues show up in juvenile court, but I thought it might be helpful just to provide the briefest of backgrounds about what juvenile court is. So in North Carolina, starting when a child is 6 years old, kids can be prosecuted in juvenile court, which is part of the state's district court, up until their 16th birthday for alleged violations of the criminal law. Last year, North Carolina became the last state in the nation to raise the maximum age of juvenile court jurisdiction to 18 for certain offenses. So now 16 and 17-year-olds also are prosecuted in juvenile court for alleged misdemeanors and lower level felonies. And for 16 and 17-year-olds who are charged with more serious felonies or with motor vehicle offenses, they will be prosecuted in adult superior court. So along with its delinquency jurisdiction, juvenile court also has jurisdiction or power over so-called undisciplined offenses. And undisciplined offenses are activities that violate the law only because of the age of the person allegedly committing them. So for example, a child who's 16 or 17 years old and who is in any of the following categories: regularly disobedient to and beyond the disciplinary control of the parent or guardian, or who is regularly found in places where it is unlawful for them to be, or who has run away from home for a period of more than 24 hours, and a child up to the age of 16 who is regularly absent from school can be subject to the undisciplined jurisdiction of the juvenile court. Okay, so let's talk about 3 discrete kinds of problems that a child could have in school that could either lead to a delinquency charge, an undisciplined charge, or a probation violation. So if a child is adjudicated delinquent, they are often placed on probation, and school problems can end up causing them to have a probation violation and then intensify their involvement in the juvenile court. All right, so that first little column there, discipline issues. So let's think back to James. So he throws his elbow, hits the SRO, is running. He's charged with disorderly conduct in school and prosecuted. So he's referred directly to court because of the school-based incident. If James were to be adjudicated delinquent, and he unfortunately probably would be, absent some vigorous advocacy and willingness on the part of other stakeholders to be creative about other ways of handling this, he would be placed on some kind of probation, usually supervised by a juvenile court employed court counselor. And some of the typical terms of that probation would be avoid further school disciplinary incidents or follow all school rules. So as I said, if James doesn't do that, and he's got a track record that suggests that he's gonna have a hard time doing that, he can be violated on his probation, and then the probation can be extended. He could actually be placed in a juvenile detention facility and other negative consequences. All right, so the second column there talks about how attendance problems can land a child in court. So here I mentioned that the juvenile court has jurisdiction over young people who are habitually truant. So if a child is not going to school, she can be sent to court for truancy and placed on what's called protective supervision, and then similarly would have to attend school regularly and other things. There could be kind of the kitchen sink of disciplinary terms that are made part of protective supervision. But if she does not do that, she will likely have that protective supervision extended. And then finally, academic and social emotional problems can kind of simmer underneath in a school setting and lead a child to act out in ways that often are really just a manifestation of the child's frustration, but can look like criminal activity depending on the person doing the looking. And so like the child who is disciplined, he could be sent to court, placed on probation, and then have these common discipline probation violations. Okay, next slide, please. So this chart, which comes from the Department of Public Safety, just breaks down exactly what it is that kids are allegedly doing to get sent to juvenile court. I think there's something of a misconception that kids are in court for violent offenses, for serious offenses, and for the most part, for the overwhelming most part, they are not. They are there for misdemeanors and lower level felonies like breaking and or entering, breaking or entering a motor vehicle. And as you can see, huge numbers of these cases originate from schools, except for larceny. Well over 50% of all of these offenses start out in a school. Next slide, please. So this, again, is information that comes from the Department of Public Safety. And what this does is paint a picture of the kind of more complicated story of a James. So you can see here that the children who are sent to juvenile court have lots and lots of mental health diagnoses. So the situation is much more complicated than just, are they being bad? But it's more like, who are they and what has brought them to this moment? And in many cases, it is significant mental health issues. Next slide, please. So this slide shows the population, the number of mental health diagnoses for children who are in youth development centers. Youth development centers is really the juvenile court equivalent of a state prison. So it's the most serious consequence for a delinquency offense. And you can see here that kids who are in the state's YDCs overwhelmingly have quite complicated mental health diagnoses. And the trauma percentage really stands out. In 2017, 100% of committed youth had at least one mental health diagnosis. I feel compelled here to point out that that the misspelling of intellectual was not me and Jen. Don't blame us. Okay. We tried to fix it, but we couldn't. Okay, next slide, please. So Jen mentioned the historical moment that we're in, and it feels worth echoing that really, I think we're being asked to reckon with a legacy of systemic racism, structural violence that has disproportionately landed people of color, and especially Black people, in our nation's juvenile criminal courts, jails, and prisons. So Black men comprise 13% of the male population nationwide, but 35% of those who are incarcerated. 1 in 3 Black men born today can expect to be incarcerated in his lifetime, compared to 1 in 6 Latinx men and 1 in 17 white men. Black women are similarly impacted. And for kids, for juvenile delinquency complaints that initiate in schools, there are similar dramatic racial disparities. So Black students represent statewide 25% of the student body, but 47% of children sent to court. And it's not because they are acting in ways that violate the criminal law in proportions that exceed their representation in the statewide population. We need to consider what our systems are doing to create these kinds of disparities, specifically over-policing, implicit bias, and lack of cultural competency among adult stakeholders. Next slide, please. I wanted to just give folks a sense of what it means to go to juvenile court. So it's not a one-shot deal. The decision to send a child to juvenile court means that the child can have multiple court appearances, which means the child is missing school and the parent is missing work. And our state's delinquency courts, like the rest of the nation's, are overwhelmingly poor people's courts. And so missing a day of work for our parents has significant and negative financial consequences. So a child could go to so I would say 5 court appearances is common, and often it's more because cases just get continued, often with little regard for the burden that it places on children and families. Next slide, please. So again, it's not easy to be in juvenile court. We talked a little bit, I talked a little bit earlier about the different kinds of dispositional terms that can be placed on a child who's put on probation. And I have been doing this for a very, very long time in several different states. And what has always struck me is that there seems to be an expectation on the part of prosecutors, court counselors, and judges that simply telling a child you are now adjudicated delinquent and placing him or her on probation is suddenly going to magically turn around a child's life. So what we can see, so if a kid like James gets placed on probation and things like these kinds of terms would be terms that would be ordered for him, and they might not seem like things that should be hard for a child to do when things are going well, but for our kids, they are very difficult. And in a lot of cases, the probation terms are really all stick and no carrot. It's kind of like, just do this. And that's just what you have to do as part of your probation. And it's very uncommon to have there be incentives for doing this. So what I often suggest when I'm representing kids or my students is, how about if the child is placed on probation for a year, if they do these things for 6 months, we can end their probation early. And there's like a real reluctance to do that. I mean, Jen mentioned once the kid is in court, it can be, I don't know if she uses this phrase, but like a runaway train. And the system has this weird gravitational pull. Once a kid is in there, it's hard for them to kind of get out. Next slide, please. All right, so the collateral consequences. To be sure, the collateral consequences of a juvenile delinquency adjudication are not of the same gravity as a criminal conviction. And that's one of the reasons why it's so important that we raise the maximum age, as we did in 2019, of juvenile court jurisdiction. So it used to be that if you were 16 or 17 and you got into a fight in school, that would be a misdemeanor conviction that you would then have to report on job applications. And that is somewhat diminished for delinquency adjudication, but not entirely. So a child who has delinquency adjudications can be prohibited from playing sports. They may have to report it on college applications, because sometimes the questions are phrased not, do you have a criminal conviction, but have you ever been arrested or charged with any crime anywhere? Housing, I really want to raise up, because parents who have Section 8 vouchers, for example, are told that if there's any criminal activity that occurs in their housing, they can lose their Section 8 voucher. And so we worked this year with a family where the kids were charged with breaking into a vacant apartment, essentially. And it ended up that the mom did not lose her Section 8 voucher, but she was threatened with that. And so I think it's important to just point out that in addition to the probation, there are also all these kind of other consequences that extend into the child and parent's life that can follow him or her for years. And similarly, it's not only the child but the parent. So if one is to initiate a truancy petition against a parent, she too will have to miss work. And if there's a conviction, there will be an array of consequences as well. So that's not our focus for this presentation, but just to point out that consequences are not minor, even when the offense seems to be.
All right. So a lot of what Barb has just covered was shared kind of with the goal of shining a light on why juvenile court is often not the appropriate place for therapeutically addressing student misbehavior. There may be situations where they're very, very violent, serious offenses, but as she was showing in that chart, that's not the bulk of what's being sent over. And I will say when I first started, it was my experience, and even when I was working within the juvenile court systems, juvenile court was seen as this benign thing, like we're gonna send kids there so they can get help. And I think over the years of working in this sphere, I've learned that number one, juvenile court can cause a lot more harm than help. Just that Barb mentioned that students are kind of adjudicated delinquent, and there's been lots of research showing that just that label of adjudicating a student or a young person kind of sets them on that path. Like when you're labeled as delinquent and bad, that triggers kind of this, well, this is my identity. And so it's really fuel for me ways of how can we prevent that? Because we've identified these needs. So going back to those first questions of like, what are the needs? What's the fun, like what's causing the behavior? And how can we better address those? And so now I want to turn back to, again, with the grounding that juvenile court is not typically going to be the best way to address that. How can we build up supports within the school environment to prevent these behaviors from happening in the first place? Or if they do happen because they're going to, kids are kids, how do we more therapeutically intervene to address those behaviors? And I'm going to focus most heavily in this part on students with disabilities, in part because that's, as you saw from the stats, a large percentage of students that are being referred to court, but also because there are such powerful protections for students with disabilities, thanks to federal special education law. And in my experience, utilizing some of those protections in a really creative, zealous way can make all of the difference in these youth lives and progress. That said, I feel like this presentation and kind of this whole discussion around equity is always full of caveats. I do want to stress that special education is a system in and of itself. And so it can also be utilized in a way that increases inequity. So for example, research consistently shows that students of color, and particularly Black boys, are routinely over-identified in the area of serious emotional disability. And so it's this really difficult line to walk, because on the one hand, being qualified for special education services, as I'm going to talk about, can open up the door to lots of creative, individualized supports. But on the other, being found eligible for SPED services requires that label that, I talked about the label of being, delinquent. For some kids and families, that label can have a stigmatizing effect. And so we always want to be, again, as I encourage people to ask that question of why are we choosing to criminalize, also being really thoughtful of why are we choosing to apply this label, and is special education the right system to be utilizing, or can we address needs the other way? Again, 90% of my practice is probably within special education, so I do believe strongly in it, but I just wanted to raise that flag that we always have to be, because it's a system, it operates as the rest of ours do, and it can create inequity and can foster these disparities. And so just wanted to have that flag from the outset that we also need to be thinking through and assessing constantly with that. So with that being said, let's jump into special education rights. And I really want to get in the coming slides about some really concrete, practical strategies that you can be utilizing within your classrooms and within your schools. So first, from the kind of higher level, for those of you that aren't as familiar, so special education rights derive from the Individuals with Disabilities and Education Act, the IDEA, which is a federal law that I always describe as essentially a disability civil rights law. So it was passed in order to provide enhanced protections for students with disabilities. Originally, the target population when the law was created was really focusing on students with emotional disabilities who were being kind of wholesale excluded from school or warehoused in separate schools and facilities. And so the goal of the law was to really build in supports within the school environment to, number one, ensure that these students' individualized needs were being met. And that's, I've got on the slide, so one of the fundamental guarantees is FAPE, so a free or public education that has to take into account the students' individualized needs and how we can support them to make progress. And we also have to take into account how we're going to educate those students in what's called the least restrictive environment. And so that goes to, again, when I said when the law was passed, students were being kind of warehoused in separate settings or excluded from school from just fully. And so the least restrictive environment protection gets at, we want these students to be mainstreamed in regular classes to the greatest extent possible. We can push in other supports, we can try other things, but we don't want to be kind of segregating students with disabilities unless we've shown that we can't meet their needs in these other environments. So those are kind of the fundamental guarantees of the law. And in terms of who is eligible for those protections, we're talking about students. So just having a disability is not sufficient. It may be sufficient to get access to supports under a Section 504 plan, which just requires that you have a disability and the disability impairs a major life activity. With special education protections, the student has to have a disability that impairs their ability to learn, and that because of that impairment, they need individualized instruction from a special education teacher. So that's called specialized instruction. And how I tend to kind of conceptualize that in my mind is that they need someone with special training to help teach them in a different way, to help them overcome some of those skill deficits, or they need to be able to show what they know in a different way. So we're modifying the curriculum or the instruction in some way, and that's where we get into that needing specialized instruction. There's a broad, the law encompasses, there's 14 categories of eligibility, and those categories encompass pretty much any disability, as long as you are meeting some of those thresholds about impacting learning and then requiring that specialized instruction. And I want to focus on some of the ones that Barb had raised in an earlier slide that we see common to students being referred into court. So some of those included learning disabilities and some emotional disabilities. There was conduct disorder, I believe, was on there, PTSD and trauma-related disorders, and as well as ADHD. And so all of those disabilities can qualify for an IEP, again, assuming those categories or those criteria of impact on learning and needing special education are met. And I think sometimes those are, I think people readily think of special education for students with autism or significant learning disabilities, intellectual disabilities, any of those. And I think they less readily think of special education as being supports for students with emotional disabilities. Because one part, they're like, well, how does that affect learning? That's just, regulating emotions. But, using James' case as an example, he was getting suspended. And so that's a direct impact on your ability to learn. If your disability-related behaviors are causing you to get suspended, then you're not there to learn. So that's an impact. And then as far as the question of, well, what would specialized instruction look like? How would those students need specialized instruction? For a lot of our students, they need that special ed teacher to be able to kind of work in an individualized manner with them on kind of building coping skills and learning how to respond to these triggers in a different way. And so those supports can provide lots and lots of resiliency factors for students and can make all of the difference. And so if that criteria is met, then the students will be eligible. And there's lots more that can be said about the eligibility and some of that process. And so I've included a link here. We've got toolkits on our website that go more in depth about that and provide sample forms that you can use, but that's kind of the nutshell of the overview of protections that are afforded. And now I'm going to spend some time really going into the well, what does that look like in the nuts and bolts, and kind of how do you go through that assessment of, is it working? What else can we be doing? So I tend to, when I get a case, I run through these questions in my mind, and I'll refer back to James to try to make this more directly applicable. And so the first question I ask when I get a case where the student is struggling, and that can mean struggling academically or getting suspended a lot, the first thing I want to know is, do they have an IEP? Because again, an IEP provides such significant supports. In James's case, we already know that he has an IEP, so that's not as relevant to him. However, I do want to take this as an opportunity to stress that oftentimes behaviors that we're seeing popping up can be an indication of an unmet disability-related need. And schools have an affirmative, what's called child find duty. So that's another key protection of the law, because special education law is super complicated. Lots of parents don't know that their children may be eligible. And so there's a key affirmative responsibility under the law for schools to be identifying whether a student may be in need of special education services and to refer them for further evaluation so we can get to the root of that cause. So again, in James' situation, he has an IEP, but if you have a situation with a student who has been consistently failing despite some interventions, if their behaviors kind of go 0 to 60 in a way that you're like, that's not typical of a 12-year-old that I regularly work with, that could raise some flags that would necessitate this referral for an evaluation to learn more. So then the next question I look at is, so if a student has an IEP, as a threshold matter, want to know, well, what's the IEP targeting? And have we really addressed all areas of need? So again, back to James, we had said that his eligibility category is under the serious emotional disability category. And so we know in that IEP, I would expect to see goals related to peer interactions or adult interactions and things like that, as well as some services to help supplement that and help provide support for him along that. However, if you notice in the facts, it also said that he had been failing most of his classes, and I think it was particularly skipping math class. And so in my experience, again, when we're looking at on the surface, that just looks like a defiant child. I can't even count the number of times I've had a case where it just looks like the child's being willfully defiant, won't go to math, and just doesn't care. It turns out they can't do the work. In my experience, students would much rather be seen as, quote, bad than dumb. And so wanting to get a sense that could there be some learning issues as well. It may just be that the emotional disability is what's causing the interference, but we also want to be looking holistically at, like, are there learning needs that we're not identifying? So I would want to know, is his IEP, does it have goals that are trying to address learning deficits, and are we building in special ed supports to address any of those? And if I'm not seeing that, then that would raise a red flag for me of, we need to look back at the IEP and see if we need to include some more supports and be looking at some additional areas. And so the next two categories is in kind of getting even further in. So like, and these are the ones that I want to spend a little bit more time on, because I see them not being utilized quite as creatively as I think they can and should be a lot of times. And so those are the kind of looking at, are the related services and the accommodations appropriate, and are we using appropriate behavioral interventions? So first, I'm going to take a minute to talk through accommodations and related services. So when I'm talking about accommodations, these are different supports that a student can be receiving typically within the classroom. It can also be within the school environment, but those typically happen within the classroom to help remove some of the disability-related behaviors or barriers. The common ones we see are testing accommodations. And so, for example, if a student has ADHD, there'll be the accommodation that they get to take their tests in a separate room, or they get to have extended time on tests. They may be able to mark their answers in the book instead of having to do the Scantron and then transfer over. And those are great accommodations, don't get me wrong. But I will say in my experience, those tend to be the bulk of what's in there. But it's limitless for what can be in there. So accommodations can literally be anything to help remove that disability-related behavior. So if you do have a student with sensory needs or attention needs, being able to utilize fidget spinners, or I've seen I've had teachers use TheraBand, which is kind of given that kind of sensory input so they can still sit in their chair and kind of have that productive fidgeting while still staying in the classroom. Opportunities for the student to do heavy work, so kind of just getting up and moving around, taking books somewhere, the stress balls, things like that. It can be as creative and individualized as possible. And again, what I tend to see in IEPs are just these testing accommodations. And so, for example, with James, I would really want to see creative ones for him, because if we know that he may be dealing with underlying trauma and getting overwhelmed by a lot of the classroom environment, giving him built-in opportunities to have breaks or built-in opportunities to have a separate space where he goes if he's feeling overwhelmed can make all the difference. And that's not removing him from the environment, it's just kind of building in these kind of breaks and supports so we can keep him on track. Related services are another really, really important support within special education, and kind of along the same lines of accommodations, I regularly see the kind of standard related services. And so I would say that in my experience, those are like occupational therapy, physical therapy, speech therapy. Those seem to be the ones that schools are readily equipped to do because they have speech pathologists on staff, they do the evaluations, and can provide this for students who have difficulties with handwriting or with motor deficits or with speech. I will say even within those, if we get into the other ones, I still see them being used in a bit more of a limited way. So for example, occupational therapy in my experience has been more narrowly used for kind of those if the students are having trouble with handwriting. So helping them with the grip of the pencil and some of those functional skills, which are very important. But I was fortunate early in my career to have a case involving twin autistic students who were incredibly smart, but had a lot of the typical autistic sensory seeking behaviors. And so I got involved because there was a push to remove them from the classroom and put them in a separate classroom. But the family had independent occupational therapists. And thanks to that, I was able to get like 5 pages of these really creative recommendations for the school to be implementing to address these sensory seeking behaviors. And occupational therapists have such incredible training around addressing sensory deficits that, again, this is not to be a blanket statement, but in a lot of cases I've seen, I haven't been seeing OTs being pulled in to work with those kind of deficits. By the same token, speech language pathologists, I regularly see them being pulled in to help with if a student is having like articulation errors and stuttering and any of that. And again, that's a really great support. But for a lot of our youth, that when we dig a little deeper, we find that a lot of their behaviors are stemming from the fact that their expressive language skills are really, really low. So they literally cannot express what they need to communicate. And so then their behavior becomes their communication. And it has made all the difference to identify that and pull in speech language pathologists to help work with the student and help work with the teachers on building up that capacity. Because otherwise we just would have labeled that student as pure behavior kid, but it's not that. It is not necessarily behaviors that need to be regulated. The underlying cause is the expressive language. Some of the other related services that I want to highlight that are rarely used in my experience are counseling as a related service. And I want to stress that this is not mental health counseling. This is not a substitute for community-based therapy. However, it can be a really, really, really powerful source for our young people to have opportunities to connect with a school counselor or psychologist in a way that they can kind of build some of these coping skills and work through some of their struggles. Another one that I rarely see used is called parent counseling and training. It is in the law. I transcribed it from the law. I doubt many of you have seen this in your schools, But in the cases where I've been able to advocate to get it, it can be a really important way of connecting that parent back into the IEP team, back into the kids service delivery. It's been impactful in my experience for students that have pretty complicated needs, and they're getting lots of support in schools, but the parents have no grounding in like, well, how do I replicate this at home, and how should I be working with them at home to increase this continuity? And so I've had really good success in building in parent counseling as part of the IEP to help really plug the parent into that process. And so that's also come up now in this in the pandemic, with parents now having to, by necessity, be kind of stand-in teachers and stand-in OT. And so building parent counseling into these IEPs, particularly while our students are remote, can be really impactful to make sure that they feel involved and supported. And how do I continue these supports while I'm at home? And then the last key support that I wanted to talk through are these behavioral interventions. I cannot stress enough how huge these have been for the youth that I've worked with. Because again, the framing that I started with is wanting to not just look at the behaviors we see, but what's at the root of them, what is causing the behaviors. And I'm hoping most, if not all of y'all, have heard the terms functional behavioral assessment and behavior intervention plan. But if you have not, please start using these in your schools, because functional behavioral assessments, or FBAs, are incredibly powerful tools for getting at the root of what is causing a student's behavior. So FBAs are data-driven assessments. They're supposed to be driven by weeks of pretty deliberate data collection. So we identify our problem behavior. So for example, perhaps a student is routinely arguing with a teacher or refusing to turn in work. And so we want to collect data on, well, when is this behavior happening? Because it's really easy to say, like, well, he just doesn't care. But let's find out a little bit more about that. And so through the FBA process, you collect data on, well, is he refusing work in all classes, or is it just in certain classes? Who's around when he's refusing work? Is it at certain times of the day or later parts of the day? And I will say, over the years, through really well executed FBAs, we've been able to learn, number one, that some of these issues are academic and not just behavior. So the issues are only happening in math. And as I mentioned, a lot of our students would far rather kind of come across as bad or find ways to escape than let it be known that they have no idea what's going on in class. We've also been able to see, like, oh, these behaviors are only ramping up after, 3 o'clock. And it turns out that the student has recently switched to a new medication that seems to be wearing off. And so then it actually turns into a medical issue that we need to consult with their psychiatrist to get a sense of titrating that and figuring out the best dosage. And so I can't stress enough how key doing these functional behavioral assessments can be to really getting at the root cause. And then that in turn informs what are called these behavior intervention plans. And these are really important because while the IEP and the accommodations that we're talking about and all of that are really targeted at the youth, behavior plans are about the adults in the room. It's really targeted at, okay, now that we know what the students' triggers are and what their needs are, how are we, number one, going to take steps to remove those triggers? And then number two, when the student does get triggered, because we know they will, how are we going to intervene therapeutically to de-escalate that? And then also, how are we going to give key opportunities to practice and reinforce when they're engaging in what we call the replacement behavior that we want them to be doing instead? And so again, going back to James, a plan like this can make all the difference. Say for example, as part of his underlying trauma, if he gets touched, he goes off. And again, we don't have the full facts, but I've had enough cases that I suspect that's what happened in that case. The SRO came up behind, probably with best of intentions, just wanted to redirect. But for kids who have been through trauma, if you put a hand on them, the response is going to be to do that. And so if we know that, then we can build in supports through a behavior intervention plan that says, use verbal redirects with these students, or if they are agitated, build in these safe spaces, have kind of a list of talk to this person, then this person. We can map out ways to reinforce in the moment that's going to be supportive but not escalating. I cannot stress enough how powerful these plans are. And so in particular, before we're thinking about referring a kid to court, I would want to know, have we tried these things? And that's, again, not to say that it's not frustrating, you all don't have enough on your plate, but just looking through, have we tried to incorporate these supports? Have we tried a behavior plan? Have we pulled in all the right people? OT, PT, schools have such a wealth of resources that if we can get them into this team environment can make such a difference for young people. I get, as you'll see, I get excited and I keep going to the special ed. And so in the last 5 minutes or so, I also want to be sure to touch on, because again, I can't stress enough, there's so much that can be done within the school environment to support kids. But then what if the student needs more intensive or different help than that would be available through the IEP process? So I also want to encourage you guys to still think through of like, well, who are the people, like if we've identified that they need more, they need something else, like who are the people within the school environment that we might can tag to try to access some of those supports, either within the school environment or to try to connect with community-based supports. So are there social workers, counselors, district level staff that can help navigate some of those supports? Or if you don't have those within your school, what are your ready community partners that can help with that? So I'm thinking of within legal aid, we have what are called health navigators that help families navigate through the enrollment process for the affordable care, benefits counselors through the food bank. We have social workers on staff in our agency, and there are lots of community-based agencies. And so there are community supports that you can tap into when we're looking at, are there mental health needs, or is there a need for tapping into therapeutic programs? And so I guess starting with the mental health needs, again, I talked about when you may have the opportunity to get school-based counseling as a related service, but some students may need more intensive support than that. And so I've heard many times of kids being referred to the court system so they can get connected with services, but that doesn't have to happen. There are ways to connect through to mental health agencies without going through the court system. And so in some districts, and some of you all may have this, there's what are called co-located mental health services where community-based agencies will actually provide mental health services within the school system. And others, when that's not an option, every county has what's called an MCO, a managed care organization that's contracted with the state to receive Medicaid money and manages the care of the beneficiaries who can receive services from mental health, developmental disabilities, and substance use. And so I've included on here the link for figuring out who is my MCO. And so that can be something that a social worker or counselor at the school can help a family navigate through. It's information that can be given directly to a family for them to help navigate, or other community partners to help them navigate. But there are ways to directly link up to get those more enhanced services without having to go through the court system. By the same token, and we've included these as kind of in the bucket of therapeutic programs, there are lots of community-based programs that are specifically intended to help support youth development for coping strategies. So that can be mentorship programs, skill building activities, horse therapy programs, boxing programs. And a lot of these are offered. So if a kid goes through the court system, they'll be referred to some of those, but they don't have to go through the court system. And so we've included some links on here that you can access to try to locate some of these yourself and navigate, because a lot of these community programs accept referrals as a prevention for court referral. So to plug students into those before they get into the court system. And then finally, I wanted to flag, because again, this is not to say that we don't want to be, we've been focusing a lot on the healing aspect and addressing the underlying needs, but we also understand that there needs to be accountability. And so want to encourage you to be looking at what are the ways that we can utilize and incorporate restorative justice practices to do that. And as a lot of you know, restorative justice practices look at kind of making, repairing the harm. And so making this like the victim whole, as well as involving the offender in that. And so number one, look at, do we have restorative programs within our school? A lot of schools are really trying hard to incorporate these supports within their school setting through peer mediation, through kind of school-based circles and other programs. Included a link to a video about a restorative circle program in Oakland, California. That's really, really inspiring if that's something that you would want to explore within your school. And then also included some information about how to access community-based supports for programs that are funded through the Juvenile Crime Prevention Council. And there's programs like Teen Court and other peer mediation programs can be accessed just straight through the community without going through the court system. And again, these get at that restorative angle without the risk of all those collateral consequences that Barb had raised. So we have gotten to the end of our time. There's lots and lots to talk about. And I see that there's lots of comments that we have not had the chance to get to. But I believe and I hope Alex can share the comments with us after. And I know we can share the PowerPoint. And so I'll be happy to read through, and if there are specific questions, type up answers and send those out along with the PowerPoint. And I also want to stress, hopefully you've been able to gather from this presentation that we're incredibly passionate about this and are always happy to talk through, brainstorm through options. If you have questions about juvenile court, that process, collateral consequences, I've included Barb's information on here. If you have questions about special education, students' rights, feel free to contact me. And I've also included contact information for our social worker on staff, Katie Haberman, who helped compile the resources related to community-based supports. And she has said to have people feel free to reach out to her if they just want to, if they have specific questions or just want to brainstorm through. We believe passionately about this and would love to continue to partner with any of you guys on this. So I think we're right at our hour.
You did it. You did it. Thank you, Jen and Barb. And can everyone hear me? I gather that you can, I hope. So first of all, I want to thank you for both of you for your extraordinary presentation. My head is spinning. I'm in a good way. I'm very excited to, and I'm sure everyone else is excited to know that, again, you will have access to all this entire presentation. We're going to be uploading it to our YouTube channel for this conference. We're going to be sharing it via email. So you will have all the access you need to revisit, because I know I'm going to be revisiting this myself. I'm going to drop in something that I'm also sure that you guys are fairly interested in, which is the evaluation form, because that gives you, once you fill that out, you can get your certificate of attendance for the session. So I'm going to drop that into the chat now. I'm going to do it a few times because it might get lost in a sea of appropriate thank yous to our presenters. So here's the presentation, the form right now. I'm just going to keep dropping it in. Evaluation, and there, and I'm going to keep doing it. So if you click on that link and you fill it out, in the next, I believe the turnaround should be a couple of days. It shouldn't be very long. You'll get your certificate in your email, and as I said, you'll get also an email with additional information with a link to the recording, and you'll have the link to our YouTube channel where you can view all of the sessions by that point. It says it's no longer accepting responses. Okay, I can see a few. Apparently, I will follow up with that, and let me actually chat someone really fast. And if not, we will email. We have the contact information. Let me double check. 1 second here, and whoops. So what we'll do is the email, obviously the survey doesn't appear to be accepting responses at this moment. We have all of the contact information. We will look through all of you who are who are currently there right now. We have 307 participants right now, 306. So we have all of you who are currently in the session. And we will make sure to get in touch with you and make sure that you have the evaluation so that you can get your certificate of completion for it. Does that work? So apologies that we don't actually have, there's obviously a setting wrong that we can't fix literally in the moment, but we will be sure to take care of that for you. So when you registered, we should have some information for you. Thank you all. Thank you. And yeah, so if you do want to put your email in, if we don't have your email address, if you're not confident we have your email address, if you could drop it in the chat, that will be completely fine too. And we will send out the registration. I see a sea of email addresses, which is fantastic. So we will get through those, and we'll make sure that that it is working. Once I stop seeing email addresses, we'll know we're good to go. And I will not be the one sorting through all these email addresses. So somebody else will be doing that on our team. But thank you both. Thank you to, I don't know if Jen and Barb, if you have any final thoughts or anything to let everyone go with, because it really was, you know, again, I don't know that I probably wouldn't, I definitely wouldn't be as effusive as I am if I didn't think it really was extraordinary. And I know this is something that I'm going to definitely be using in our professional learning ourselves. So I'll be taking bits and pieces of this, and I know exactly, I can already visualize where it's going. So thank you so much for your wonderful presentation today.
Well, we're really grateful to have had the opportunity to be here with you all today. And again, if we can continue to be further supports, I've included, we got lots of resources on our legal aid website. Barb has published a lot of research and whatnot around this. And so definitely, however we can be partners in this, we are all in.
Thank you.
Great, thanks to both of you. And we'll remain here. I will remain here. Barb and Jen, you guys, you can do whatever you'd like, just to confirm that all of the email addresses are being put in the chat. And once I stop seeing email addresses, I'll give another 5 minutes or so. Then we will close up shop, and you will have, we'll send out the recording once it's all set.
Bye.
Thank you.
And Kelly, you will get the slides too. Yeah, slides and the presentation as well. And thank you both. And again, if you are unable to access a survey, which appears there's a technical glitch with it, if you put your email address in the chat, we will send you that survey. So if you can go ahead and do that. And once you've done that, we'll have your email address and we'll be ready to go. So thank you so much for your flexibility here. No worries, Ivy. If you just want to drop your email in the chat, that would be great. Thank you so much. You're all set. So just to reiterate, we're going to be sending the survey at some point today via email. And if you could just drop your email in the chat, if you're not confident that we already have it, we'll send it out to you and you'll be able to take it, because there's something a little fouled up in the settings, I believe. So we'll keep this open for another 2 minutes. And if you please, in that time, if you can, add your email address to the chat if you haven't already done so. And we just have a few people left in the room, and we'll go up and close up. And again, as I said, about 2 minutes.